Happy New Year to everyone, and welcome to tonight's meeting of the Committee of Adjustment. This is a meeting to consider applications for minor variance and consents that's held under the authority of the Planning Act of Ontario. Please keep in mind the intent of this process is to review the proposal that's before us, listen to all the evidence, and then make a decision. This process is not intended to be used to resolve any concerns or disputes that may exist between the town, individuals, or organizations. If a request for a deferral is made this evening and the committee grants such a request, the committee, after consultation with our Secretary-Treasurer, will set a new hearing date. No further notice will be provided unless there are changes to the application. In order to conduct an effective and efficient hearing, we have adopted the following process that we ask that everyone abide by. The owner or authorized agent will be given the opportunity, if so desired, to briefly explain to us the basis of the application and answer any questions that may arise out of the hearing. A maximum of 5 minutes will be provided for this presentation. You need to state your full name and address for the record, and any material submitted to committee for viewing will remain the property of this committee. Any submissions beyond the 5 minutes will be at the discretion of this committee. All persons attending the hearing this evening who wish to support or oppose the application must also state your full name and address for the record. A maximum of 5 minutes will be provided to make your presentation. All remarks and questions are to be directed to the chairperson of the committee, and any submissions beyond the 5 minutes will also be at the discretion of this committee. If there are several speakers sharing the same view, please select a spokesperson to represent the group's combined opinion. We want to hear all your views, however, covering the same points will not assist us in arriving at a quicker decision. The owner or agent will then be provided with a further 5 minutes to respond to comments made by any interested parties and answer any questions from the committee members. If the owner or agent has any concerns found in the staff report, particularly with any of the proposed conditions, this will be your opportunity to advise us. The matter is then taken to committee for a decision, and that will mark the end of all discussion. Once our committee makes an oral decision, any person desiring a copy must file with the Secretary-Treasurer at this meeting a written request for notice of the decision, and we provided a green sheet in the back table that we ask that you please fill out and leave with us before you depart the hearing tonight. Please note that you must make your written request in order to be included on the list that is used by the interim municipal board for giving of any subsequent notice of appeal. Written notice of the committee's decision will be mailed not later than 10 days for a minor variance and 15 days for any consents to the applicant, the owner and or agent, and any other person who filed a written request for such notice. If you do not agree with the committee's decision, you may appeal this to the Ontario Municipal Board. The last date to appeal the decision to the Ontario Municipal Board will be noted on the decision. If no appeal is received within the prescribed time frame, the decision of this committee becomes final and binding, and our Secretary-Treasurer will then notify the applicant through further written correspondence. People attending the meeting this evening are to be courteous to and respectful of the members of the committee, town staff, and other people in attendance tonight. Also to advise you that tonight's meeting will be live streamed and available for future viewing on the town's live stream webpage at oakville.ca/live. We ask that cellular phones and pages be switched off or put into silent mode during the duration of this meeting. Thank you. And we have two regrets this evening. I think Mr. Tilowski and Mr. Hardcastle cannot join us this evening. Members of those that are here, anyone have any declaration of any pecuniary interest? Seeing none. Okay. Is there anyone here this evening that wishes to either defer or withdraw an application? Yes, sir.
Hello, members of committee. My name is Bruce McCall Richmond. I'm here on behalf of Glenn Schnarr and Associates. The mailing address is 10 Kingsbridge Garden Circle, Suite 700 in Mississauga, Ontario. Postal code is L5R 3K6. I've been retained by Steve Hamlin Architecture on behalf of Henry Silva, the owner of 1295 Tansley Drive.
So this is CAV 04 2018?
That's correct.
Okay.
I'm requesting a deferral of the application on the basis that we have not had an opportunity to address the comments noted in the staff report, and we would like additional time to discuss and address the comments with staff.
Okay, thank you. Is anyone here this evening that has an interest in application CAVA 004 2018 for 1295 Tansley Drive? Okay, you are. Oh, there's a few hands. So the agent has requested a deferral because I guess they probably read the staff report, and they have some concerns they wish to explore and address and make revisions to the application, hopefully that may address the concerns. Can you just turn around, sir? Can you show the hands here?
I guess.
Okay, these are the people it's critical for you to meet.
Sure.
So, members, any discussion on deferral requests? We normally grant first deferral requests. I know it's a huge inconvenience for those that trucked out here tonight in the snow, and it's not fair, but I think in order to advance the best interest of the application and see if there's some resolution that can happen in advance of the committee meeting, we're going to defer this matter. The next available date is when?
Earliest can be February 27th.
February 27th.
Is the earliest.
The earliest. So depending on how well you approach the neighbors and have a discussion, which I encourage you once you leave the room to exchange phone numbers and set up meeting things, and then get back to our Secretary Treasurer when you have an idea of what amendments you wish to pursue, if any. And then we'll get you back on the agenda when we can. But the earliest will be the 27th, and there's a deferral fee, of course.
Okay, acknowledged. Thank you.
Thank you. This matter is deferred, and sign a die, I guess, until you get back to us. Okay, anyone else wishing to defer an application or withdraw? Okay. Whoever wants to come down first, there's no priority.
Good evening, Mr. Chairman. My name is David Crothers from Crothers & Associates. I represent application 01-2018. We'd asked for a referral. This is based in, so that we can reach out to planning staff, redesign and come up with a solution that's
Okay, you're in
everybody's
the boat
gonna
as a
agree upon.
previous owner. So anyone here have an interest in application CAV 001 2018 at 260 Dalewood Drive? Okay, members, are you satisfied with the deferral request? All those in support? Okay, we'll defer that. So the same thing.
Yes.
You got to reach out to Secretary Treasurer when this matter is ready to proceed, but no earlier than the February 27th.
Great, thank you.
Okay, thank you. Sir? Let me guess, 3065 Old Bronte Road, no?
No,
Okay, sorry.
we missed that one. It's Mateos Madeiras, 333 Warminster Drive. I request a deferral for 457 Warminster Drive.
Are you the owner agent?
No, I'm asking if it
No,
can be
hang
deferred.
on, but are you you're just an interested party?
Yes,
Okay,
and the reasons being is that the sign is being removed for
What
about
sign?
a week. The signage on in front of 457 or whatever the address is,
yes.
and you can see the picture there.
Well, let
And
me
it
get
was
my- let me
removed
get-
for, I mean, it's here, but it's been removed for at least a week, and it was just placed back today. And this is the second time it happens, and I think the developer knew this, and it should have been made aware to the people living there that this is a very important signage and it should not be removed, so that the public has enough time to see.
Okay, let's just see, just don't go too far. We may have some debate on this one. Is the owner agent applicant here for I guess CAVA 121 2017? 457 Warminster Drive? All right, do you want to speak to deferral request? No, you can leave that up there, sir.
So the issue of the signage is as confusing to us as it is, I'm sure, to the community. We have been out there to put up the signs. As soon as the town notified us that the signs were not there, we went out that day and put them back up again. I am an agent for the owner. I'm Emma West from Bousfields. So when we get the notice from the
We
town.
didn't get your name and address.
Emma West,
Okay, you
Bousfields,
got it.
3
Thanks.
Church Street.
Okay. Yeah, so
200
you were
Toronto.
notified, you went out, put it
So
on?
we were notified, we went and put the signs up again. We were notified again today. And interestingly enough, today, when we were notified that the signs weren't up, when we went out, the signs were actually there, and there were no footprints in the snow. So it's very confusing to us as well. We've responded as quickly as we possibly can in terms of getting out here to get the new signs and putting them up again. It's our understanding that the owner and the people that they rent the properties to are not involved in taking the signs down. So we don't know if there's someone in the community who's taking them down if they have blown down. It's not clear to us, but we've made our best efforts, and each time we have gone out to put the
Okay.
signs back up,
Okay.
we've sent notice to the town.
Okay, thank you. Is there anything you wish to add to this? No? Okay, sir, in terms of the signage, it's a complementary statutory requirement in addition to the notice that is circulated to everyone within a 60-meter circulation distance. So those immediate neighbors that have an interest not only get the signage up to let them know where the property is located, it's really an identifier and also encourages someone to come and ask questions or seek more information. But those immediately abutting the property within 60 meters are given direct mail notifications. So they are, presumably, if they have an interest, they're here. And I'm assuming that you're within that 60-meter catchment area and you are here tonight. So it's effective. We did have notice, and you heard some reason notice goes up unless you have a 24/7 security guard, which is not a requirement that we have. You have to use your best efforts. Sometimes inclement weather takes it down. Sometimes there's vandalism that takes it down. And we heard evidence from and undisputed evidence from the agent that they tried their best, and every time they were notified, they try to correct it, but sometimes things are outside their control. So on that basis, we're going to proceed with the application in order that we have it listed, and we encourage you to stay with us and share your concerns. Okay, thank you. Anyone else wishing to defer or withdraw an application? All right, so we'll start in the order that the applications are listed. We're going to deal with a package of applications. This is a consent application B1701 at 263 Spears Road. And they're going to be heard concurrently with two minor variance applications, CAVA 203-2017 and CAVA 204-2017. They're all at, again, 263 Spears Road. The agent owner applicant is here.
Hello, committee. So my name is Anthony Turco. I'm agent for Oakville Italian Bakery Limited. And yes, we're addressing consent and the application for variance.
Yes.
So yeah, basically we're just
Okay,
asking.
just before you proceed, we have a procedural bylaw that allows us to dispense of the full presentation where circumstances warrant.
Okay.
And one of those circumstances would be if there's anyone here this evening that has an interest in the application. Can I see a show of hands? These are the three applications together. Okay, this is a situation where recommended by staff subject to a condition. Members, you want any further explanation on this application? Secretary Treasurer, did we have any written correspondence on this, emails or otherwise? No. Okay, so we have none. Sir, we're ready to dispense of the full public presentation.
Okay.
Subject to anything that you wish to add, any clarification, anything that you think that we don't already have in our package that we should know about.
Yeah, I've provided everything that I could. So I think you've got everything you need.
Okay. So, members, are you ready to proceed in the application? We'll start off with the consent first, the test under section 5124 of the Planning Act.
Sure, Mr. Chairman. I'm prepared to move use this one for now. I'm prepared to move a motion to approve the consent application. I believe it is appropriate land division and it's consistent with the lot fabric of the neighborhood. I believe that it does conform to the livable Oakville as well as the zoning bylaw. And it does confirm section 54, and I'll make it subject to the appendix conditions in, do we have an appendix A?
Appendix A conditions.
Yes.
Schedule A, yeah.
So you find that the application is not premature and it meets the test under section 154 of the
Yes.
Planning Act, and you support it subject to the conditions in Appendix A.
Yes, thank you, Mr.
Sir, you read those conditions?
Yes, I have.
Okay. Discussion on the recommendation? See none, all those in support? Okay, that's been approved. Yeah, there was no written submissions. This is something we established in the beginning.
beginning, yeah.
Yes, no written submissions. Okay, could you proceed with application CAVA 203, 2017?
So on that note, we'll
and
proceed
204,
with the,
2017?
yes, the variance applications that are connected to this severance. CAV 203 of 2017 and CAV 204 of 2017. And I'll move a recommendation to approve those variances as they are minor in nature and do conform, they do meet the four tests and are applicable variances that are required with the consent.
Okay, so the staff note, the variances are to recognize existing surface parking conditions, and the staff note in their proposed condition that to the extent that these are accepted, that they meet the four tests like you indicated, that it be subject to the condition to reflect existing conditions, and if there was a redevelopment, they would need to go through a different process. So you're in agreement with that condition as well?
Yes.
Okay, thank you, sir. You know about that condition, right?
Yes, I do. Yeah,
Okay.
there's no proposed redevelopment there.
Again, there's no oral or written submissions on this file, so the recommendation is to approve subject to that condition that we heard. Any discussion? Seeing none, all those in support? No one opposed, sir, your application's been approved.
Thank you.
First ones of 2018, congratulations.
Thank you very much. Thanks for hearing me, Mr. Chairman and committee. Thank
Good
you.
night. Okay, then we'll proceed with application, okay, the other one was deferred, the Dalewood. We'll proceed with application CAV 002, 2018 at 2058 Seafair Drive. The owner agent here? Yes.
Good evening, members of the committee. Joris Kieran Design. I'm the agent for the applicant. Address is 100 Bronte Road, Unit 10 in Oakville.
Okay, Mr. Curran, just before we proceed, I'd like to see if there's anyone here this evening have an interest in application CAV 002 2018 at 2058 Seafair Drive. Okay, sir, here in support or opposition?
Clarification in order, I just want to clarify one matter before I oppose it or...
Okay, so can we do this? Can we ask you to maybe, do you want to wait to hear the presentation, or we can have your questions so Mr. Curran can be prepared, or we can go in whatever you prefer?
If you'd like me to go...
Sure, why don't you come up? I mean, we're trying to be efficient with everyone's time here. Maybe you can give us your name and address for the record.
No problem.
And then give us the nature of your concern, and Mr. Curran can concentrate on that. You can hear the presentation, so you can then make your election.
Thanks. So my name's Matthew Retzi. I live at 250 Seafair Drive in Oakville, next door.
Yes?
And Heather, in her recommendations, actually addressed, for the most part, the concerns myself and the neighbors had, which the central concern was a large maple tree. And she made note that she recommends or requires that the plans be resubmitted to try and maintain the tree. I guess my only question would be, for those recommendations, and sorry, a question of ignorance, but how binding is that? Is that just something that is a recommendation that, can later be amended?
Yeah, so you're talking
according to the
about
plan?
process. Now, first of all, we got to establish who made that recommendation to you.
Sorry, so Heather did? Heather,
Okay, so you're talking about the condition of approval, which originates from planning staff, and I guess Ms. Kate Mahavelich can speak to it. But those conditions are conditions that are effective. You can't seek your variance approval if it was to be approved until that condition is satisfied, and it would be to the satisfaction of director planner. So they have discretion. to say, yes, the condition has been satisfied, or no, the condition has not been satisfied. If it's a no, then the applicant, agent, or the owner has to do whatever is required in order to reach that level of satisfaction. So it's a trigger for a review, and Ms. Mahavlich can add further to it, so you can understand the process. And then, subject to what you hear, then you might want to say, yes, I have a presentation I want to make, or I'm satisfied, and then we'll have Mr. Curran to do his presentation.
Thank you. Through you, Mr. Chairman, the process would be that the applicant submit to us information pertaining to the health and vitality of the existing tree. It's unclear to us right now if it is in a condition of poor health and is required to be removed. So an arborist report through the normal process would be submitted for us to confirm. And if it is demonstrated that the tree is in good health and should be protected, then we would work with the applicant to discuss a revised driveway design or potentially revised driveway material that would have less of an impact on the health of the tree and its existing condition. And that would go through the regular process and review with the Director of Planning.
Okay.
So I think the town shares a similar concern, and you're talking about the tree that's right next door to the driveway. It appears to be outside the canopy, but again, it needs to be assessed. And
Okay.
depending on the health, and you heard the submissions from Ms. Mahavlich. Now, based on what you heard, sir, do you wish a full presentation in this particular instance? Do you need to hear more about the project and all that stuff?
Well, I guess if there's any appeal to the subject or the condition. If not, if everybody's in agreement that all efforts are made to save the tree, then I would have no further objection.
Okay, so what it appears to be the case, and this is why we poll in the beginning, so we don't spend 20, 30 minutes on an application where we can hone in on the real issue and see if we can address it. It appears that staff are satisfied. We still need to consider the application. We've read the staff report like you have. We did our site visit, and we read the application. We understand it quite well. And we are generally prepared to proceed with the application, but we wanted to make sure you had an opportunity to consider your position on it.
Yeah, so I mean, it really was just going to come down to, you know, if exceeding the limitations of the house, of the footprint of the house, is what's putting that tree potentially in peril, then I would argue against allowing.
Correct.
That, you know, but if everybody's in agreement, all efforts are going to be
So
made.
you're okay with the variances as long as there's attention paid to the tree?
Correct.
And you're comfortable with a condition that leaves a discretion of that driveway location to be determined by the Director of Planning after receipt of the information that you heard there?
That's
Okay.
correct.
Okay, thank you. Mr.
Thanks.
Curran, is there anything else you wish to add on the application, sir? You heard the submissions, and I guess you understand that there's some work need to be done. Have you received an arborist report on this particular property yet?
Not at this stage. We typically get that at the building permit stage or just before the building permit stage. So we will be getting one, and we will get a full write-up on that tree, and then we can go from there. Just to, you know, I did want to speak to this point a little bit and to clarify a few things. It's the owner's intention also to save this tree. That was the original intent. We don't know the health of the tree, so if the tree's in failing health, then obviously that's a different story. But the owner wishes to retain the tree if it's possible, but he needs to get access to that bay, you know, that garage, that portion of the garage. So we're okay with the condition, but as long as it still permits vehicular, you know, access to that bay. Now, I think that can be achieved in various ways. We can curve the driveway slightly.
Right,
we can
right.
add different permeable material.
Right.
But, you know, we wouldn't accept it if it meant, you know, going down to a one-car driveway, because then it would make that one bay not function. So we're in agreeing to it up to a certain extent, I guess.
Yeah, no, I think planning staff said the same thing, that they're willing to work with the applicant to achieve the design if that gets approved by the committee, but understanding there's further work to be done. Like you said, it could involve different solutions or a combination of different solutions, including permeable pavers or other type of surface treatment, plus swerving the driveway a bit or what have you. It all depends on the health of the tree and what needs to be done in order to protect its integrity. Oftentimes, we do our best to protect trees, and if they're in failing health, they become a health hazard as well. So, you know, all these things need to be put into the hopper when you make a full and wholesome decision on these type of situations. Okay, having said that, members, any questions, any items of clarification? Ready to proceed on that, on the application? Yes, Mr. Charlebois?
Just one question for the applicant, because if we go along with the recommendation that's written in here, it basically says that, and I'll read it to you. It says, proposed dwelling be constructed in general accordance with the plans dated December the 5th, 2017, is submitted subject to a revised driveway design that protects the affected tree to the satisfaction of the Director of Planning, which essentially means if you can't reach an agreement with the Director of Planning and you can't get access to your bay, your C of A will die, and you will have to look at another alternative.
Yeah, well, I was going to request, and if we can add one sentence to that clause to say, as you know, as long as vehicular access is maintained,
Well,
or something along the lines that would at least guarantee my client that access.
well, but I heard, I think you heard, and this is all live, and you can go back and reflect on it. I think you heard that the intent is that the town wants to work with the applicant and also wants to work with the neighbor in protecting that tree. It's consistent with your client's own interest. And there's an understanding that you need a garage. It's required for parking purposes, and you need a driveway to get to it. So I don't read this condition to say, well, if we can't resolve it, then you know, you can't have it. I think what I heard was they're going to work towards a solution that protects the integrity of the tree if it's in a state that needs protection. You know, if it's not, then it's a different consideration. I think that's what Ms. Mahavlich said. Is there anything further you wish to add on this? Is there any chance that, you know, to put something on the record for Mr. Jurin that says, oh no, there could be a chance that you will never get access?
Through you, Mr. Chairman, I think that as long as the applicant keeps an open mind as to what happens with the configuration of the garage, its current location, the position of the dwelling, there's some, you know, space within the building envelope that the dwelling could move a few inches here or there to provide for a driveway that is clear of the trunk, and again, working through thoughtful design on the surface treatment area to improve what impacts might be on that tree. I think that there would be a solution that would allow for a 2-car garage on this property. But again, without understanding what the tree's conditions are and knowing what we're up against, it would be difficult to guarantee anything at this point. We're merely protecting for the interests of that tree.
Yeah. I mean, I think when you look at the plans, to put the tree in the other side would be not the preferred solution. This seems to be the best location for the driveway and the garage. And I think, you know, everyone's interest is to ensure that everyone's concerns are addressed, including your clients. Okay, we're going to take things a little bit out of the ordinary here to reach a resolution. Quickly, sir, what is it?
I guess just a quick question.
But you got to come here, though, because this is all recorded. We have to make sure that we capture your image.
Nobody would be objecting to a 2-car garage, but if the garage was kept within the limits of the 45 square meters as opposed to 56, if that in effect would save the tree, I would rather, myself and the neighbors would rather that the applicant adheres to the 45 square foot garage as opposed to removes a tree to maintain the 56 meter
if you
garage.
study the plans, it's not the size of the garage, but more importantly is the driveway. So whether it's a 1-car garage or a 2-car garage, or it's a 46 square meter garage or a 56 square meter garage, you still need a driveway, and the driveway.
For sure.
And the driveway needs to go close to the tree. And it shows right now that it's, it's past the drip line. So it's really not the size of the garage, it's the location of the driveway, which I think we all understand what the issue is.
Okay.
There is a site alteration permit that's required. There will be a building permit that's required, and through that process, there'll be a tree report. And you can keep in touch with the applicant. You can also keep in touch with the town. They'll provide you that report. I'm sure they can give you that to review it. But these are experts that can pretty well understand the health of the tree. and they can provide certain construction methods, if you will, or protection methods and treatment methods on the driveway that ensure the long-term viability of the tree. I think that's
All right.
everyone's interest.
Well, thank you for the time and consideration.
Thank you. Okay, having that discussion, now we're going to take it to committee unless there's anything else you wish to add, sir. I think we had a thorough discussion on that condition. Everyone is of the same mind.
Agreed.
Okay. Recommendation or any questions? Okay, let's have a recommendation, Mr. Charlebois, thank you.
All right, Mr. Chairman. Having conducted my site visit and reviewed the applicant's submission, as well as the town's written report, and taking into account the comments from the public as well as the applicant, I'm going to make a recommendation that these particular variances do meet the 4 tests under the Planning Act, make a recommendation that they be approved, subject to, Mr. Kieran, taking into account your request, just so you know, with respect to the condition, I really can't see a way to give you some other language in here to protect you, because I really don't know what the situation is. So I think the best, I'm going to make a recommendation is to go along with the condition that the town asked for, which was that the proposed dwelling be constructed in general accordance with the plans dated December the 5th, 2017 as submitted, subject to a revised driveway design that protects the affected tree to the satisfaction of the Director of Planning, and subject further to the condition that this approval will expire 2 years from the date of this decision if the proposed development does not proceed or a building permit is not issued.
Okay, thank you for that. A discussion on a recommendation? See none. All those in support? No one opposed. The application is approved. I guess we should also reflect the fact that there was no written or oral comments beyond what? Yes, okay, thank you. Nothing beyond, okay. All right, your application's been approved, sir. So we'll then proceed to application CAV 003 2018 at 1088 Kent Avenue.
Good evening, Mr. Chairman. My name is Bassam Halabi. The address is 1088 Kent Avenue, and I'm a professional engineer.
Okay, sir, thank you. Let's just see if there's anyone here this evening that has an interest in application CAVA 003 2018 at 1088 Kent Avenue. Okay, see none. Members, again, I'm in your hands. You wish a full presentation? Any items of clarification? Any?
I have one clarification myself, if you allow me.
Sorry, just hang on. Yes, you had something to add to the application, sir?
Yes, the staff basically they have no objection to these variances. They did recommend to get a site alteration permit. They were. Okay. So the reason they asked for it is for the drainage. They were concerned about the drainage due to the reduced side yard. I want to mention that the front yard is higher than the backyard, so the drainage doesn't go to the front yard, it goes to the backyard. And then there is a low point in the backyard, and there is a sump pump. And then it's pumped back to the front on the other side of the side yard, not the reduced side yard. There is another side yard which is about 10 feet wide. So if possible, to remove that condition.
Well, we can't remove an engineering condition, sir.
Okay.
Okay, it's a condition that is not within our jurisdiction to remove. It's
Okay.
not an amendment to the bylaw. It's a requirement for every citizen in the town of Oakville. When they apply for a building permit, they need to have a site alteration permit.
Okay.
It's not something, it's actually not part of a recommendation. This is like a heads up note to you. By the way, you'll need a site alteration permit. And I'm sure all those engineering matters that you just raised will be resolved.
Okay.
You know, it's normal practice. Okay, so you have nothing to add on the application? We can take it into committee?
Yes, please.
Okay, thank you. Mr. Charlebois, you had a question?
No, it was dealt with there, Mr. Chairman. Thank you.
Okay, so let's have a recommendation. Who would like to move a recommendation?
Mr. Chairman, I'll move a recommendation to approve this application based on our site visits and the reports of the town as well. The proposed addition impacts only the interior side yard, and there's no negative impact to the facade. It's well within the envelope of the neighborhood, provided that the site plan shows, I guess, the drainage as requested, and that will be dealt with in the site plan alteration. I believe that the variances before us are minor in nature and appropriate for the development of the site. I'll move a recommendation to approve with the condition that the town has requested that the proposed well be constructed in general accordance with the plans dated November 3rd, 2017, as submitted, as well as our standard condition that approval will expire within 2 years from the date of the decision if the proposed development has not proceeded and/or a building permit not issued.
Thank you.
And there are no, I'll add that there are no comments from the public, whether in support or in opposition.
Okay, thank you. A discussion on a recommendation? See none. All those in support? That's been approved, sir. Thank you.
Okay, thanks.
Okay. We'll proceed with application CABA 005-2018 at 3065 Old Bronte Road.
Good evening. It's Neil McDonald, 308 Winston Road,
Good
Oakville.
evening, sir. Okay, is there anyone here that has an interest in application CAB A 005-2018 at 3065 Old Bronte Road? Okay, sir, if you can proceed with the presentation.
If I could, thank you, Mr. Chair. The original project that I became involved in was back in 2005, and then we required a variance at that point, which was obtained in 2006, to permit a day nursery in an agricultural zone. One of the conditions that the committee put on at that time was that the would be for a period of 5 years, and that would expire in 2011. Subsequently, then we made a site plan application, a building permit was issued by the town of Oakville, and the residence was converted to a day nursery. Then in 2009, as you know, the zoning for the north part of the town changed, and this was zoned ED, and then the existing use was allowed under the general regulations, section 431. However, another application was made in 2010 for another variance to extend the use, and that was granted for another 5 years. Then, when that was expiring, or before it expired, we made another application in 2015, and that was to this committee, and that was granted for a period of 3 years, and that's why we're here again today. The planning department contacted me about a week ago and said that they would not support the variance. They said that a temporary rezoning would be a more appropriate way to go about doing this, and the fee for that would be about $25,000, which would be good for 3 years. And then I asked the question, what would happen after 3 years? And they said, you could apply for annual extensions at about $7,000 odd. I feel that the zone on this is the town's responsibility, and they should be actively trying to get whatever they want for this area. I have my client here, and there's two of them involved in the firm, and I think they would like to say something too. If there's any questions, I'd be.
So effectively, you just want to extend the
use has
daycare
been there
use
for 12 years.
for a period of another 5 years.
Yes.
Okay, this property is owned by your clients, or is it leased?
Sorry?
The property is owned by your clients, or is it leased?
Yes, it's owned by them.
Okay. All right, so just have a seat. We'll listen to your clients as well. So we don't want to hear a repeat of what we just heard, just new information, okay?
Okay, sounds good.
Yep, thank you. Your name and address, sir, for the record?
My name is Ramsey Mansour. I'm the owner of the property in question.
Okay.
Also the owner of 911090097 Canada Inc. I have a letter.
Is that your mailing address, sir?
No, my mailing address is 5199 Forest Ridge Drive, Mississauga, Ontario.
So, okay, slow down a bit so we can record it correctly.
Sounds good. 5199 Forest Ridge Drive in Mississauga.
Okay. Your
I
name
have,
again, sir?
I have a letter from.
So, sorry to be anal about this.
No, that's
Can we
fine.
get your name again? Because it's kind of hard to hear here, so.
Yeah, no problem.
Can you
I'll
speak in the microphone?
Yeah, I've got a bit of a cold, so I apologize.
No, it's okay.
Is that okay? Am I coming out clearly?
That's perfect.
Perfect.
But
Okay.
give us your first and last name again.
Sure. First name is Ramsey.
Ramsey,
Yeah, and last name is Mansour.
M-E-N-S-U-R?
Mansour.
Okay, thank you, sir.
You're welcome.
Appreciate that.
No problem. Now, I do have a letter that was prepared by our lawyer regarding this matter. So, is it easier to just distribute it this way or
Sure.
hand it out?
Yes.
Okay, and I've, yeah. Yeah, if you
Well,
please.
we'll take whatever you got. Put it
Yeah,
on
here
there.
you go. I've got 4 copies, so.
Virginia
Yeah, we can,
McLean,
Yeah,
was she not a former solicitor with the city of Mississauga?
that I do not know.
Yeah.
So if you don't mind, I'll just read it verbatim, just
Well,
for the
maybe we
record.
can read it just as fast as you can
Okay.
read it for us. Should we take a minute and read it?
Please, go right ahead.
Okay. We'll enter it into the record, but we can just, so is there a show of hand, people, is anyone else here speaking to this matter? Do you have an extra copy of your letter?
Only the one that I have presented here, no.
Okay. Did you get a
Oh,
copy?
we do.
Can-
Okay, thank you.
Okay, can you hand it to the residents so they can read it as well? Thank you. Ah. So here's our dilemma, sir. This is very, very illegal. It means it's a very legal letter.
Yes, it
What
is.
it says, so you're using the whole of the building for daycare right now?
We are.
Okay. So
Correct.
what your solicitor is saying is it's a legal non-conforming use. Effectively, the way I read it is you shouldn't be applying for this relief.
That seems to be the gist of the note.
So you want to withdraw your application?
I'm not sure what the result would be by withdrawing. I know that we've
Well,
got licensing requirements.
You got a legal opinion.
Mhm.
Your legal opinion says, in her opinion, it's a legal non-conforming use, and it was an existing use before the new bylaw was passed, and therefore, it appears the town's planning staff are under the erroneous impression that he can force the committee to keep giving variances that are time limited and to control all future development of the property. If council wants to pass a bylaw such as a temporary use bylaw, it can do so, but council cannot force the owner to have the bylaw passed. Council can expropriate if it cannot. This is very, very legalese. I mean, if your solicitor's opinion is you're legal non-conforming because of all the previous approvals, and when the new bylaw came in, and you got some form of Planning Act protection under section 34(9)A and B, she should have those discussions with the legal department. Because what she may be communicating, I don't know, I'm not a lawyer,
Yeah.
but she may be communicating that you don't need any relief, you don't need an approval. It might be in your best interest to have that approach and letters dated today, right?
Yes.
Yes. So it doesn't help us, we're not lawyers.
Yeah, I understand.
But what your lawyer is saying is
Neither-
you don't need,
neither are we,
you
obviously.
don't need any approval. If you don't need any approval, you got some kind of protection, it's best to defer your application and explore those options, or we can deal with it.
Okay.
It's up to you. Yes, Ms. Havlich.
Thank you. Through you, Mr. Chairman, to the committee. This is also the first time that we've
Yes.
seen this. However, planning staff with legal have also investigated Ms. McLean's opinion, as it was our our own investigation that led us down that conclusion as well. And it was our determination that where we disagree, that we don't believe that we have established a legal non-conforming use by changing the bylaw in 2009. Therefore, if Ms. McLean wishes to have conversations with our legal department to further debate the matter, then I think that the applicant might be in their best interest to defer and give themselves some opportunity to have those discussions and determine at that time if a withdrawal of their application is appropriate.
Okay.
Yes, yes, there's a question here. I'll have to ramble on with a few more thoughts because we don't want to get stuck in the legal,
Yeah.
legal tangle here of who's right or who's wrong. Yes, Mr. Shalabo.
Mr. Mihaljevic, just to keep things in perspective, though, their existing variance expires in February of this year, and discussions such as these just don't happen that fast. So if he withdraws, and they have these discussions and they can't resolve it, what happens?
Well, I don't think he's withdrawing. I think
Or no,
a deferral
if he
will allow
defers,
discussion, and it will have to come back on the 27th. So, I mean, there's an understanding, good faith understanding.
But by that time, the variance is expired.
Right, well, that's,
Through you, Mr. Chairman, to the committee, ultimately, as the chairman has indicated, on a good faith, understanding that the application process is still open and up for evaluation, the town would not proceed on any kind of enforcement matters at that time. So we do recognize that there is an expiry date upcoming, and that would put the property in jeopardy of being illegally operated at that time. However, with the expectation that there would be ongoing discussions to attempt to resolve the matter, whether by way of an application to the town or by way of a decision that the application for minor variance is no longer required, those decisions would be made in due course. So again, I would encourage the applicant to consider the conversation here this evening and potentially defer their application and have those discussions with staff and with legal in order to allow the process to continue without any hardship to them on their current uses.
Okay, thanks.
And that sounds reasonable from our perspective.
yes, Mr. McDonald.
Yes, if I may, one of the previous committee decisions said that as long as the application was made before the expiry date of the previous decision, then it would be okay. It had to be approved before that date. So I
Well,
believe
there's a whole body of case law. Again, we're not experts. It says that you have to continue the use uninterrupted to continue to claim legal nonconforming use. There could be situations where you intend to continue with the use. For example, an office use, which is legal nonconforming, it's taken you 2 or 3 months to renovate, or it's taken you, a month or two to find a tenant. You haven't discontinued the use. The intent is that you wanted to continue. You just had to get the process. So I think this falls under the same boat. What we're going to do, if you want to defer, I think it makes abundant sense because the committee does not grant variances that are not required. And if it's a legal nonconforming use, like your lawyer suggests, you need to have that discussion with the legal department. Obviously, there's been some pre-discussion, there's been some pre-decisions, but maybe Ms. McLean is persuasive, in which case you might not need a variance. We don't know. But if you do need a variance, I guess having your application in is protected. Now, what we'll ask you to do in the context of that is discuss whether or not there's an opportunity to get you on at least on the February 13th agenda. I know the 27th is a date we're targeting, but with discussions both with the chief building official, Mr. John Tuert, and the legal department, if they feel that there's a gap in there that's a problem, then if you made the decision that you want to continue with the application, see if you can get it on the 13th. That's their call, but there's a lot of work to do between now and then, and you have to come to a conclusion by this Friday, more or less. So, you have to work hard, and I think Ms. Mihaljevic has this discussion. We have the letter, and hopefully there's time to allow those discussions to occur. On that basis, we'll defer this application, but before I defer it, I wanted to ask the residents if there's anything they wish to add to this process at the moment. We're not making a decision. Do you want to register your name to show that you were here, sir? This is very, very complicated from a legal perspective. It's easy from a planning perspective, but when lawyers get involved, it gets complicated.
My name is Gurinder Singh, and 106 McCraney Street West is my residence. That is my property, 3057 Old Brownty Road, next door to 3065. We received the letters late. I did not actually review what was going on. Oh, is it? Okay. So I received the letter a bit late and I didn't review what was going on, but we were planning all the neighbors for if you would like to extend it maybe for a short period of time, but now the application has deferred and we have more time to discuss with them and see what solution we can find. Yes.
I do encourage you, though, to reach out to Mr. McDonald and the owners that are in the
Yes.
back and have those discussions,
Yes.
okay, in the interim.
Thank you.
And
Mr.
do you
Mr.
have a
Chairman.
question, Ms. McCray? Okay, sorry.
Mr. Chairman, with respect to this deferral, with your indulgence, would it not make some sense perhaps for us to agree to a deferral, but perhaps agree that we can push this thing out for a period of 3 months so that there's no question from the point of view of the applicant that
Well,
they're permitted to stay there?
that's right. I'm reluctant to go that far because there could be legal implications for having a significant gap between the expiry and any subsequent process, although there is an application in, and the intent is to continue with it. But I'd rather those discussions occur earlier rather than leave them on for future discussions. So I don't know what
So what I'm going to take from this, and I guess, this is all recorded, but from this thing here, is that the intent here is not that these discussions can't occur or whatever, or that the applicant won't have time, even if they fall apart, to come back again to this committee and ask for a variance if it wants to.
Right, it's to allow the discussion of the letter that we received from Ms. McLean that's filed as an exhibit here tonight, which has not been seen by the town or by anyone other than here tonight. And in fairness, there could be elements in that letter that could be persuasive or not. And if it's not persuasive, then the owner needs to make an election whether they rely on Ms. McLean's letter and withdraw their application or continue with the application.
Okay.
So that's sort of the different options. Okay, this matter's being deferred. And yes, and there is a fee, sir, as you know. All right. We'll continue with application CAVA 120-2017 at 366 Warminster Drive.
My name's Joshua Butcher, 3 Church Street. I'm a planner with Bousfields Inc., and I'm here with Emma West, who
are you with, sir?
Bousfields.
Oh, okay.
And I'm here with Emma West as well, who's a partner with our firm, and we are the planners and agents for the owners of 366 Warminster Drive, Green Meadow Inc.
Okay, so is there anyone here this evening that has an interest in application? You do, sir? Or ma'am, sorry, I can't see my. Okay, sorry, I couldn't. My apologies for that. My eyesight's probably 10 feet ahead. So, are you in opposition, ma'am? All right, okay, so we're not going to get into detail. We're going to ask you to proceed with the application. Give us the thoughts or give us your position on it and how it meets the 4 tests of the Planning Act, and then we'll hear from the resident.
Okay, so as you know or recall, in July, we were here before you and requested a deferral, requested our original application be deferred in order to address some concerns that have been raised by planning staff as well as the community. And we'd like to thank you for granting that deferral request. It's allowed us to meet with planning staff and also the community to make some revised changes. We met with planning in July, and then following that meeting, we revised, we worked with the architect to prepare a revised set of architectural plans. And as requested by this committee at that original July hearing, we contacted each of the residents who appeared here and raised concerns and left us with their contact information, and we arranged a drop-in community engagement meeting at the Woodside Public Library in an afternoon and evening where we discussed these revised plans. Through that process, it was our understanding that we had adequately addressed most of the massing and the overall scale and height issues that had been addressed. We resubmitted the plans, which is what is before you today. The proposal is to demolish the existing one-story dwelling and replace it with a two-story dwelling. There are two variances, one relating to residential floor area and one relating to front main wall proportionality. Planning staff have reviewed this revised proposal, and they have issued a staff report suggesting that they are in support of this application and the two variances, and they conclude that they meet the four tests of the Planning Act. We have not, with this application, received any additional written communication expressing concerns with it. It's our opinion that the revised proposal meets the four tests of the Planning Act, and we would request that the committee consider approving the application.
Sir, can you just briefly tell us how the variances were changed from the original application?
Yep. So I can actually pull this up for you. So column 1 is what the bylaw permits.
Right.
And column 2 here, what the items in red were variances.
Right.
So originally we had a front yard setback of 9.74 meters. Now it's 10.42. It
So
complies.
you comply now, you made
Yeah.
it comply, okay.
The flankage yard was always fine. The
Right.
interior side yard was always fine.
Right.
The rear yard was originally 4.79 meters. It's now 7.455
So you
and
made that comply, yes?
We were originally at a height of 9.5 meters. We've now dropped down to 8.61 and tucked more of the second story into the attic,
Okay.
as requested by planning. The lot coverage was originally 30.7, is now 24.98, and it
Right.
now complies with the zoning bylaw. We originally requested a residential floor area ratio of 48.73, whereas the bylaw permits 38.
Okay.
We are now requesting 40.83, so a minimal increase. And then the front main wall proportionality, it was originally fine, but as a result of the revised changes, we shrunk the house and we shifted it away from the lot lines. And you will see here.
What does that minimum main wall proportionality mean?
So it means that 50% of your front main wall has to be within the minimum and maximum front yard setback. It was originally fine, but because we squished the dwelling and we shifted it further to the road, and the front lot line curves dramatically, and that's what actually resulted in this variance, was actually addressing the concerns of shifting the dwelling away from 374 Warminster to the north and 362 Small Crescent to the west.
Okay, so for that intent to meet the other requirements and the urban design?
Originally it was not there, yeah.
Okay, thank you. Any questions? Okay, thank you, sir, for your presentation. So, ma'am, it's your turn. Yeah, can you leave that chart for us?
Yep, for sure.
Okay, you're okay now? I think I'm okay. Okay, you don't want to register your name and address for the record? Okay, so there'll be a voice in the recording, but no face. Okay, anyone else wishing to speak to the committee on application CAVA 120-2017? See none, okay, we'll take this matter to committee. Members, may I have your recommendation? Mr. Charlevoix.
Sure, Mr. Chairman. Again, having conducted my site visit, I reviewed the applicant's written submission as well as the town's written staff report, and also taken into account the comments made by the applicant this evening. I do note that we had some questions from the public, but no objections. I also note that there's no written or other oral objections or support from the public. Looking at these particular two variance requests, I find that they do meet the four tests under the Planning Act. I do note that the applicant is looking for a little bit more residential area, but having said that, they have worked very well within the building envelope to attain that, and they're not asking for any variances to the building envelope itself. So I'm going to make a recommendation that we approve this particular condition, or sorry, this particular application for variance, subject to the condition that the proposed dwelling be constructed in general accordance with the plans as submitted, and subject further to condition that the approval will expire 2 years from the date of this decision if the proposed development does not proceed or a building permit is not issued.
Thank you. Any discussion or recommendation? I just want to add that I think the deferral was used very wisely. You've arrived at a very good solution that is obviously embraced by staff and the community, and we're encouraged by that. Thank you for your efforts. No discussion recommendation, subject to approval with those two conditions. All those in support? No one opposed. That application being approved. Okay, we'll proceed to application CAVA 121-2017. This is at 457 Warminster Drive.
I'm back.
You are indeed.
Yes.
But you'll have to give us your name and address again for the record.
So I'll put this up again. Joshua Butcher, 3 Church Street, with Bouse Fields. And Green Meadow also owns this property at 457 Warminster Drive, and they are our client.
So this is the one with the sign problem, but it didn't exist on the other one.
Yes.
Okay, so let's see, sir. You have a concern that you want to explore with us? Okay. Anyone else? Okay, there's a few others. So why don't you proceed with the presentation on this, sir?
So this application, similar to the previous application, we were here in July. We requested a deferral. There were concerns raised by staff and with the community, and we thank you for granting that deferral. At that same meeting, we also met with planning staff to discuss potential revisions to this property. At the committee meeting, following that meeting, we also made revisions to the plans, and as requested by this committee in August, we also scheduled a community engagement meeting, and we contacted all of the people who provided their contact information to explain and discuss potential revisions to these plans. We also then met with the owner of 453 Warminster Drive at his home. So just so you can see, so the subject site is here. There's the Catholic school to the north, the park to the east, 453 Warminster to the south, and it's the only residential lot that directly abuts the property along Warminster Drive. They expressed concerns with the proximity of the dwelling to their rear deck. So following our meeting with him, we revised the plans further, which is what the package that you have before you. And we actually then further notched out this corner here to increase the separation in the rear yard from his rear deck. So this is the application before you. As you can see on this chart, we have gone down from 4 original variances to 2. And staff have reviewed this revised proposal. They have written a letter of support or indicating that they believe that the 2 variances meet the 4 tests of the Planning Act. We also have had 3 letters since submitting this application. So one came from the Halton Catholic District School Board. They indicated, it was basically a notice indicating that the school is going to be demolished and reconstructed sometime in 2008, that they wanted to notify us that that is going to occur. There may be temporary uses such as portables in the driveway, and that they don't want us to construct a gate in the fence along their property line, which our client has no issue with. We also received an email from Georgia Mulvale of 1252 Wood Place, which is the property located to the southeast. So it doesn't directly abut our property, but it's just to the southeast, and it fronts onto Wood Place here, expressing some concerns with the scale of the dwelling. We did meet with her in August. when she came to meet with us to discuss the revised proposal. And finally, we received a third email from Douglas Barker on behalf of Pat and Jim Rushbrook, who are the owners of 453 Warminster. They've indicated that they are generally supportive of the application subject to these revised changes, but they'd like to impose some conditions. We have worked with them in the last 24 hours to actually refine the wording, but they generally relate to the location of an eaves trough along the south property line, the location of downspouts to direct water away from their property, to conduct a pre and post construction survey of their property to make sure there's no damage, and an advisory note of the location of the utilities. We actually, because there's so many conditions here, I have actually put them in a Word document. If I can circulate that to you if you want to see them all. We know that some of them are maybe atypical conditions, but we generally do want to work with all of the neighbors, and we would be happy to have any of these conditions added to any final decision.
We may have further questions on the conditions.
Okay.
But we
Okay.
do have them on a word sheet. There are 4 of them.
Yeah, okay. I've amended that one since.
Well, you might want to give it to us.
Yeah. So this one now just breaks down the staff, Halton, and then the neighbors.
So is the owner of 457 here? Or 453 here?
We have a
Okay.
representative
Okay.
from what group?
All right, because we may have some questions on the conditions. So your position is you accept all these 7 conditions?
Yeah.
Okay, we may have some questions of planning staff. Okay, sir, name and address for the record?
Yes, sir, Mr. Chairman. My name is Doug Barker, 110 Chisholm Street, Oakville. I'm here representing my friend, Mr. Jim Rushbrook, who Jim with his wife are the owners of 453 Warminster Drive. As has been outlined to you, we have reviewed with the applicant some changes where Mr. and Mrs. Rushbrook are generally supportive of the application now in its form. We appreciate the changes that have been made. Subject to the conditions that were outlined to you, Mr. Rushbrook and his wife would have no further objection to this application. The concern was that this area, Mr. Rushbrook and his wife have owned this home for a number of years. They know this area is on fill. So the request for the downspouts to dispose of drainage away from the side yard between the houses and to do the pre and post survey is just to protect the owners from construction.
Okay, just on your specific conditions, the one dealing with the eaves trough. We don't have any knowledge or any reason to believe that the town of Oakville, through its site grading process, an engineering requirement, that this condition doesn't fetter their hands to determine the best drainage for the site. We don't know that. There is a process that's involved that addresses that. And, you know, although it says there to be an eaves trough, that's fine. And that grading and drainage be constructed in accordance with the plans, you know, and it says notwithstanding the natural drainage. That concerns me. I don't know what the natural drainage is. I don't know what we're trying to achieve, but. Yes, thank you for that. I don't know what the natural drainage is, and I don't know whether we as a committee have the authority to say, notwithstanding that, you know, we're going to make this happen. It's like, I don't know what that involves. And I'd be concerned to attach a condition.
Can we say something like subject
No,
to the
no,
engineering
just, you're
department?
going to hear our concerns and then you can address. So I have a real concern about that. The pre and post construction survey to be responsible for any damage on your client's property. Well, there is a thing called the Occupiers Liability Act that provides for any damage that's done as a result of entry onto your property to be corrected. So that seems almost redundant. And the condition that says, be aware there's utilities there, well, they need to have a utility located. And of course, if the utilities are damaged, they have to be repaired and replaced. So I don't know what that condition, but my concern is conditions effectively become a rezoning, or they have the effect of zoning. And these conditions seem to me, at least, are covered in other legislation or do not appear to be appropriate conditions, and they might not be enforceable. And we're creating a catch-22. Those are my concerns. I don't know if the committee shares them. So I want you to reflect on that. I mean, I think you put it on the record, rightly so. We will file this with the thing, but I understand that the agents and applicants want to work with you and achieve all these results. There's no reason why they wouldn't do it, even in the absence of them being conditions. And I want to hear what Ms. Kate Mahavlich has to say in respect of those 3 particular conditions, and we'll deal with the other ones as they arise.
Through you, Mr. Chairman of the committee, staff had been made aware of these proposed conditions earlier today, and through our discussions, it's our opinion that these conditions actually can't be enforced through a minor variance process, and nor does it actually allow the chief building official to issue a building permit, because these types of conditions are intended to be satisfied after construction has occurred. So to fetter the minor variance process with these types of conditions is, as you indicated, a bit of a cyclical problem, whereby the chief building official would not be able to issue a permit in order for these conditions to actually result in any kind of fruition. Additionally, the town is typically not involved in executing or administering any kind of private agreements between property owners. These types of conditions would otherwise appear more in a civil matter between the 2 property owners to ensure that they are, in fact, good neighbors through that process. I will reiterate that at the end of last year, the chief building official, through a number of other departments of the town, did implement the Good Neighbor Guide, which does address a number of these types of concerns around the drainage, around pre and post construction, and what happens during the construction process. As you indicated, these conditions are otherwise covered off by the site alteration permit process. They are covered off by the inspections process that happens through the building permit, and as well as through by law enforcement. So we have the tools that are available to the neighboring resident to implement should there be any issues to arise. However, I believe that if the applicant and the neighbor wish to enter into their own agreement to resolve these matters, it is completely up to them.
Okay, so I am concerned about those conditions, but we'll reflect on them during our decision process. Is there any questions of Mr. Barker? Okay, thank you, sir. Thank you for your submissions. Who else would like to speak to the committee? Okay, yes, sir. While Mr. Medeiros comes down, Ms. Mahavlich, what about the conditions from the school board?
Through you, Mr. Chairman, those aren't really conditions. They're advisory notes, similar to what we would get from the region or the Conservation Authority. And as the applicants indicated, they acknowledge that they're there, that construction on this school will happen in the near future. And it's just to advise the resident or the developer in this case that those changes are going to happen in the vicinity of their proposal. I don't believe that they're conditions that should be implemented as part of any decision that you make this evening.
Mr. Medeiros, welcome back.
Oh, thank you. I just have a question regarding the
Yeah, we need your address at this point.
333 Warminster Drive, Oakville.
Okay, thank you.
I brought an aerial photo
Perfect.
of the existing home.
Okay.
And as you can see,
Where's your house?
Oh, my house is further down, this way.
Okay.
Here.
Okay.
This side here.
Thank you.
As you can see, this tree here
Yes.
is fairly mature,
Yes.
and I'd like to know from the builder if they plan to demolish that tree, because I do not see on the revised drawing. I do see the tree on the original plan, but I do not see the tree on the new home. And and if there's plans to protect that tree, because it's the only tree and it's been there for a while.
Okay, we will ask for that clarification for you. Anything else, sir?
Yeah, and I'm a little concerned with the variance. Yeah, it's over here. It's 33. I mean, they firstly requested 45% variance. Now it's down to 38%.
Right?
No, sorry.
Yeah, that's coverage. Are you talking about the last one?
Yeah, I'm
The
talking about the
43?
last one where
Yes.
there's a massive change. Yeah, still 59%, and the allowable 43.
Right. So what does
I
that
still
mean
have
to you? Yeah.
if you look around the area, I don't think we ever had approving a home that had a 38% variance.
No, you mean 59.
Well, if you look at the difference in percentage from this 329 to 239.
90 square meters?
Yeah, that is that's a large difference.
Not 900 square feet, yes.
Yeah, and I don't think the committee has ever in the area approved such variances.
Yeah, but we don't usually deal with a mathematical equation on variances for setbacks or heights or FSIs and all that. We look at the impact.
Well, I'm looking at the impact.
So
and
that's what I'd like to hear. What's the impact of this
I
on
think
you?
the construction size does not conform with the area. Like this home is so large for the lot.
Okay.
Like we're only dealing with 500 square meters, right?
Right. So the coverage is at 38%. That means that's how much of the lot it covers. And it's a two-story building. So let's say if a story was taken off, right? Or the second story was reduced in size, they could probably make it conform to the residential floor area ratio. So I'm trying to understand what the additional 90 square meters, it sounds substantial for sure. I'm
It
trying to
does sound
understand how does that impact you? Usually, when we ask that question,
It becomes disproportionate for what's existing in the area
okay.
for the lot size.
So you're saying it's overbuilding and
It's overbuilding
disproportionate.
it, right? I can come here and say I need, 70% variance, and then the next day I come and says, you know what, we reduced to 60%. I'm making you happy that way. But
Yeah,
it's still large.
Sometimes
It's still
when you deal with issues of impact, we normally hear things like there's a shadow impact. So my rear yard is no longer in sunlight, it's in shadow. We have impacts like windows are in the area and, I'm losing my privacy. But we also heard overbuilding and disproportionate to the lot, but it's right next door to the school, right? It's not in the middle
and
of the
so
block.
to the other neighbors that have already expressed concerns.
The one other neighbor, who else? There are some others that written in here, yes? we
Yeah,
have
I
that.
think the one on, it's here, I don't know, the house behind it.
Okay.
I think she's here too, right there.
Okay,
She has also expressed the same concerns.
okay,
So,
we will ask the same question.
And I brought up the tree, right? I mean, that's a huge concern for me.
Right, so we have that tree.
That's, because I don't see it on the plans.
Okay,
I see it on the original drawing, but I don't see it on the,
okay, we'll
future
ask
plans.
about that. Thank you. Any questions? Sir, you're gonna have to leave your stuff again. We always take in all the evidence. Thank you.
Actually, my question is directed at planning, but it is related to the size of this building. I don't quite understand your comments in here where you say that the subject site's one of the
Sir,
smallest.
you can't hear, right, sir?
we can't hear.
Sir,
Do you want to come closer, or we'll try to amplify our voice a bit? Sorry? Oh, are you at 457?
yes.
You have something more to add? Okay, just bear with me a second. There's a question here from the member, and we'll get to you in a minute, okay? Okay. We're going to have to explore your concerns. Mr. Charlebois?
So I'm trying to understand the argument that, and maybe you can help clarify it, that the as of right permissions make the house disproportionate, so why don't we just make it bigger and then it'll conform? I don't get that kind of reasoning. I'm trying to understand why that's the argument, is that the as of right would already make the house big, so that's why we're going to agree to allow it to be bigger. Or am I reading this incorrectly?
Through you, Mr. Chairman, to the committee, the comments provided by planning staff are to understand the contextual nature of the property in the surrounding area. So as we've identified, the property is abutting the school. It's also abutting a much larger lot to both behind it and beside it. And across the street is, or kitty corner would be, another larger lot and park space. So contextually speaking, this lot is not like any of the other lots or in the surrounding area that would be. It's also one of the smallest lots, or is the smallest lot within that particular context. So if starting with our comments from that basis, we can recognize and have supported increases in the residential floor area, coupled with the appropriate design, which builds the second floor into the roof and provides for sympathetic transition to the existing dwelling that is there next to it at 453. It's our position that in the scale and recognizing the effective impact is very minimal in this particular case, because it does allow for a dwelling that is proportioned to what is existing in the surrounding area. I hope that clarifies.
Okay, it does. Okay, thanks.
Okay, thank you for that. Sir, you had a question. I do. Now, I understood your concerns were relayed to us by Mr. Barker. Is that correct? If I can get up. Okay, come on up. First, we'll have your name and address for the record.
My name is James Rushbrook, and I live at 453 Warminster Drive.
Okay, hang on. Did you get that? Okay, sir.
Am I
So
talking
you're
loud
just
enough
hang
in
on.
this
Just hang on.
mic?
Yeah, you'll get that.
No,
I just want to make sure we understand the terms of engagement here. So we had a letter from, or we had a representation, a letter of representation from Mr. Barker
Yes,
on your behalf?
yes.
Okay, so you will allow you to speak, and we welcome that, but don't cover points that we already covered. We want to hear new points, okay?
Well,
We
the
don't want
only thing-
repeat of the exact same points. We heard these submissions.
Yeah, there's only one thing about the new points and the old points.
Yeah, we don't want to hear the old points. We understand them quite
Well-
well. We want to know the new points.
Well, then I might as well sit down. Because
Well-
I didn't hear the new points.
Well,
I
that's
didn't-
why
didn't
I
hear
want
some
you
of
to
the
tell
stuff
me the
that
new
was going
points.
on.
What we don't want to do is we don't want to repeat the
No,
evidence.
I understand.
Okay,
But
proceed.
because I didn't hear some of the things that were going on, we might have to go over the old points.
Okay, we'll give you that leniency. Go ahead,
You
sir.
want me to understand, don't you? Because
well, that's-
I live in that house,
Yes,
yeah, with my
Proceed.
wife.
okay.
Yeah, okay. First of all, the 3 points, the conditions. Now, as far as I heard, it's not that I'm deaf, I'm just hard of hearing.
Okay,
As far as the 3 points go, there was some conversation with this young lady here, and I didn't hear all she said. Can you briefly go over that again? Just briefly. I can catch on pretty fast.
Through you, Mr. Chairman, the 3 conditions that you've requested that the applicant impose as part of this process cannot be implemented.
Okay.
There are other tools that you and the applicant can explore in order to satisfy your concerns.
Okay, you've said enough, I understand.
Perfect.
Thank you. I think you have a comment on that. You agree to those conditions?
sir, I'll chair the meeting,
Okay.
so you can speak through me, and we'll try to get whatever clarifications you
Okay,
like.
Chairman. Mr.
Any
Chairman.
other submissions, sir?
Well, I find it a little sad that you haven't stick to the figures. You mentioned something about a mathematical formula. I didn't know what that was all about.
Yes, what I indicated is variances are not just a rule or measurement of what you exceed from what the bylaw says, but it also involves an assessment of impacts.
Okay.
Okay, so there could be situations, for example, where you might need 2 parking spots, and you come for a variance to take it down to 0. That's a huge minor variance, going from 100% to
understand.
0%. And it could be considered minor, depending on the situation and the impacts. You heard this evening from our planner here, Ms. Kay Mahavlich, that her assessment for this particular property, it's not the same for every property, for this particular property, she found that the residential gross floor area, while mathematically seems huge, in her opinion, it's compatible for the reasons you heard. She doesn't
understand
always
that.
find that.
You're going over something I already understood.
Okay, I just wanted
Okay.
to give you the full context in answering
No,
your question.
I just find it curious, why I asked that question was because I'm an engineer and numbers are numbers. And when I see something like 43 and 59, and you know what I'm talking about.
Oh, yes, and I'll give you my other hypothesis.
No, just a minute, let me
Yes.
finish. Could you do that, Mr. Chairman?
Okay, yes, please.
And I find 35 to 38, they're different numbers. Now, as per the letter that Mr. Barker wrote, we agree to most of the stuff, except the 3 conditions. And as this young lady said, you can enforce those. But I believe if you talk to the, and I'd like this on record.
Sorry, say again?
I would like this minutes of meeting here, eh?
Oh, yes,
And I'd like it on record.
well, it's permanently, it's
No,
recorded.
just, can you let me talk, please?
Yes, sir, yes.
Now, I think I'd like the owner's, statement on these 3 conditions. I think he's got something to say. That's all I have to say.
All right, let me answer. Can you allow me to answer, sir?
Pardon me?
Three things. This is recorded, and it's permanently on the record. The agent already gave us submissions on the conditions. And thirdly, planning is an art, not a science, unlike an engineer where a fractional difference makes a huge impact on life safety. Planning is an art, and your submissions are valid as the planner we heard before you.
And I
So-
planned a lot in my life, too.
Yes, yes. So that's the difference between engineers and planners, but, you
Well, I
know,
planned a lot in my life, too.
thank you for
Thank
allowing
you
me
very
to
much.
make that submission, sir.
You agreed.
Anyone else?
Hello, my name is Georgina Mulvale, 1252 Wood Place, and Mulvale. Yes. Like, yes. And so my concern is the loss of green space and the lack of privacy for the neighbors. I also feel this will set a precedent for future development in the area. Yeah, that is my concern. I have a new build next door to me. My property is 6 feet, or their property is 6 feet away from the fence, which has been down for almost a year. The fence separating our properties. And this is only 4 feet, I believe, from the property line.
Meets the side yard setback.
The side, yeah.
Which property line are you interested in, front, side, or rear?
Well, the side, I'm just saying what has happened to my property with the new build next door. They're 6 feet, their house is 6 feet from the fence, and the fence has been down for a year. So this other property is, I think, only 4 feet away from the property line, the side, at the side, yeah.
1.9 on the south and 1.25 on the north.
Yeah, whatever. Anyway.
4 feet on the side and about 3.5.
Yeah. Anyway, they are my concerns. I'm just concerned about future development in the area. That this sets a precedent, and also the height of the house as well.
There is no height variance. They're lower than permitted height.
Are they? Okay.
Permitted height is 9 meters, and they dropped it to 8.64.
Thought it was 7 meters. No?
No, if you look at the chart up there, I don't know if you can see it. Sometimes the lighting in here is terrible. But if you look at the chart, you might want to move it a bit because it doesn't show all the regulations on the left.
Well, I believe what you say.
You can see it right there.
Oh, I see. Okay.
Go down more, one more. Right there.
Yeah.
See where it says 2 stories? One more. Right there. So that's a permitted height, 9
Oh,
meters.
is it? Okay.
They originally had it at 9.51 or 61, and now it's 8.64.
Okay. So those are my concerns. The loss of green space, I think, is important today.
Okay.
Okay,
So
thank you.
precedent and loss of green space, we got you. Thank you
And
very much. Any
privacy.
questions? Okay, thank you. Anyone else wishing to speak to the committee? Thank you. Okay, Mr. Butcher, back at you. Start off with the tree.
So with respect to the tree, we don't have a landscape plan at this time, and we've been dealing with the built form. As part of this process, we're not proposing to remove the tree, and in order for any sort of tree to be removed, we would need some sort of site alteration permit, an arborist report, and so at this time, we're kind of just dealing with the variance statistics. I think that there would be
No, I know, but what happened to the disappearing tree on the site plan?
I
It was, we heard submission that it was shown on the last one, not on this one.
It was just apparently left off, and we'll have to confer with
Do
the
you have
architect.
the old site plan in front of you?
I have the, I'm not sure. Yeah, it was never drawn on any of the original site plans.
It was not.
No.
So where would the neighbor have seen the tree on the site plan?
Oh, it's on the survey.
Is that the tree on your current survey?
Yeah. This was the current survey that was submitted.
Can you push it up so we can see?
Yeah.
Oh, it doesn't show the canopy, does it?
No.
Because the canopy we saw in the picture was way more than that.
Yeah. I mean, this is a boundary survey, so.
Okay. And your submissions on the rest of the stuff?
Okay, so we'd just like to point out that we recognize that, the percentage of the residential floor area ratio is increasing and has already been discussed, as this is the smallest lot on the street. And in evaluating the appropriate size of the dwelling. So just for context, 453 Warminster Drive, which is the only property that immediately abuts this property, it's, as you probably know, the Oakville zoning bylaw regulates residential floor area ratio on a sliding scale based on the lot size. The lot size of 453 is approximately 992 square meters. They are permitted a residential floor area ratio of 38, which would actually result in approximately 377 square meters. We're proposing, yes, a residential floor area ratio of 59.04, but that actually results in approximately 329 square meters of space. So our proposed dwelling is actually smaller than, but consistent with, what will be permitted on the only adjacent residential lot. That coupled with the fact that we actually meet all of the side yard setbacks, we meet the height provisions, and that we're not actually changing the envelope, and that our actual lot coverage is just a minimal increase. We think this will result in a dwelling that's actually consistent with the size of dwellings that exists along this area, or this section of Warminster Drive and the surrounding area.
Okay, thank you. Any questions? Mr. Butcher, did I say your name right?
Yes, yeah.
So your client was prepared to have these conditions
Yes.
effectively imposed on the minor variance as a means of some sort of contractual control.
So we will
So
go
here's
through
what I'm going to
other
suggest to
methods,
you.
yeah. Yeah.
Here's what I'm going to suggest to you, Mr. Barker, Mr. Rushbrook. Wouldn't it be better if you take those conditions and you turn them into an undertaking by your client? In other words, to solve the concern that this is really a private matter.
Yes.
If your client is prepared to put them into a variance approval, it would be more appropriate that you satisfy the concerns of the neighbor through an undertaking.
Yes.
Would you undertake to explore that with your client, Mr. Barker, Mr. Rushbrook?
Yes.
Mr. Rushbrook, did you understand what I just indicated? Yes, I heard that. Okay, Mr. Barker?
Yeah.
Okay, so I think there's an opportunity there to get these matters resolved outside the committee.
We agree, yeah. I mean, these conditions came up and in the interest of moving the process along, and we want to work with them, and if this is, if there's a better method, then we will absolutely pursue that.
But for future reference, you know, for everyone, you know, we have to have conditions that are manageable. Just to throw them out to appease people doesn't necessarily mean that, A, the committee will accept them and that they're enforceable. And ultimately, we want things to work.
Oh, yes, and we understand that many, particularly a lot of the drainage and the construction issues, those are definitely issues that the town, we also recognize the town manages.
Okay. All right, thank you for that.
Great.
Any questions? Seeing none, we'll take this matter into committee. Who would like to move a recommendation?
You already have.
Mr. Charlebois?
Sure, Mr. Chairman.
Thank you, sir.
Again, just as an intro, having conducted my site visit, reviewed the applicant's written submission as well as the town's written report, as well as taking into account the comments from the public, and as well as the discussions from the applicant. I do note there were a couple of written submissions, but in this case, both of the people who wrote were here at this particular meeting, had a chance to address us. In looking at this application, I must admit my first inclination was to look at the math, and like we had a comment from, I looked at the math and felt that this particular variance was quite large. However, in listening to all the discussions that went on here, I'm swayed by the town of Oakville's position. I'm also swayed too by the fact that there's one neighbor here, and that is directly impacted, and that in working together they've reached a compromise that I think is doable. So, having said that, I am prepared to put forward a motion to approve this particular variance, finding that it does meet all four tests under the Planning Act, making it subject to the condition that the proposed dwelling be constructed in general accordance with the plans as submitted, and making it further subject to the condition that the approval will expire within 2 years from the date of this decision if the proposed development does not proceed or a building permit is not issued.
Thank you, Mr. Charlebois. Discussion on that recommendation? Seeing none, all those in support? No one opposed, that application is being approved. And sir, I encourage you to sit down with the neighbor before you leave, exchange emails or telephone numbers, whatever the case may be, and work on that undertaking. Okay. we'll deal with the last application for this evening, CAVA 183-2017. This is a matter that was deferred from the November 7, 2017 at 2378 Rebecca Street. Good evening, sir. Name and address for the record.
Good afternoon, Chairman Committee. My name is Orest Stanowski. I'm an agent on this application, address 73 Abilene Drive.
Is there anyone here this evening that has an interest in the application CAVA CAVA 183-2017 at 2378 Rebecca Street? Okay, seeing none. Members, you wish a presentation? You have any items of clarification? Sir, is there anything you wish to add? We read the staff report. We've done our site visits. We understand the application. I think maybe what you can do very quickly, tell us what the changes were from the last application, and then we can take this matter to committee.
Yes, basically as per report, previous report from planning department. As per previous report from planning department, we decided to reduce the size of the building. So we shrinked it, we made it shorter to reduce the GFA to bring it down to 42 and change % instead of 45. And as per planning report, it's satisfactory.
Last time, and the only variance you need this time?
Yes, that's the only variance.
And so
we
you
require.
reduced the residential gross floor area down to something that you've been able to find a resolution with planning staff. Okay, thank you.
Correct.
Members, any items of clarification, any questions? See none. So there's no written comments, no oral submissions on this one. Who would like to move a recommendation?
I was so prepared for the other one.
Thank you, Ms. McHale.
Thank you, Mr. Chairman. I will move a recommendation to approve this application. I find that it does meet the four tests of the planning as well as the Planning Act as well as the zoning bylaw. I'm going to reiterate that it's great that the applicant took the comments of staff and brought it back with a new reduced application. I'll make note that the applicant is staying within the envelope. All the side yards and front yards are met, which this just maintains that the residential area within the envelope. Well, it whistles. What do you want me to do? Okay. I don't know where I lost my train of thought, so we'll just.
By saying that you feel that the application, subject to the condition, meets the four tests of the Planning Act. I think that's what I.
Thank you, Mr. Chairman. I'll make it subject to the condition that the town staff had requested that the proposed dwelling be constructed in general accordance with the plans as submitted November 12, 2017, and our standard condition that the approval will expire within 2 years if the development has not proceeded and/or a building permit not issued.
Okay, thank you for that thorough recommendation. Discussion on a recommendation subject to those two conditions. Okay, then all those in support? No one opposed, your application is being approved.
Thank you.
Okay, thank you. So members, we cannot deal with the December 19, 2017 minutes because both of you were absent at that meeting, but we can deal with the December 5th, 2017. Everyone read the minutes and they're prepared to accept them? Mr. Charlebois?
Mr. Chairman, I'll put forward a motion that those minutes be approved.
Okay, all those in support? Great, and then could you continue with an adjournment request?
Mr. Chairman, I'll put forward a motion that this meeting shall be adjourned.
It shall. All those in support? All right, adjourn at 8:44.